Good evening, and thanks very much for such a warm reception. It's so good to be here in Sydney among around 250 IPA members. I think this is the biggest freedom of speech briefing we've had, so thanks very much for coming out. I think we've got a real opportunity on our hands. By no means I don't think we've won a battle, but we've certainly got an opportunity over the next 3 years. And that opportunity is, as John has said, to turn the tide back on this debate and to swing the pendulum back towards freedom rather than away from it. The last 6 years, and in particular the last 12 months, have been trying times for those of us who value freedom of speech. We've seen a number of very significant threats, and I wanted to go over two of those to outline what they were and just to go through how dangerous I think they were. The first of those was Nicola Roxon's anti-discrimination law, the Human Rights and Anti-Discrimination Bill 2012. This was a bill which was proposed on, or drafted and put forward on around the 20th of November last year, and it would have radically expanded the definition of discrimination to include things like offence and insults and humiliation and intimidation. Reading through this definition of discrimination, you might have recognised it from another familiar piece of legislation, Section 18C of the Racial Discrimination Act 1975, which was the provision that was used against Andrew Bolt in a case towards the end of 2011. As I wrote in a newspaper article, this would have supercharged Section 18C. And it would have supercharged Section 18C because it applied that same test of offending and insulting conduct, not only to things, not only to discrimination around race, but around all kinds of attributes. Amazingly, some of those attributes included things like your political opinion, social origin, and religious belief. Not only did the definition include conduct that offended, insulted, humiliated, intimidated, but it also reversed the burden of proof, so that rather than the plaintiff going to court and having to prove a number of criteria before you were considered to have engaged in discrimination, it was up to you, after a claim had been made to the court, to prove your own innocence. This is a significant undermining of a principle that for hundreds and hundreds of years we've kind of taken for granted, and it's one of the reasons why I'm so passionate about the work that we do at the IPA under the Legal Rights Project, because it's these kinds of things that don't get airtime, because we have agencies like the Australian Human Rights Commission championing these rights being undermined. All costs, if a claim was made against you, all costs would have been borne by you, even if you as the defendant won that case. You'd been shown not to have been engaged in discriminatory conduct, you still would have had to pay your own legal fees. So there's no disincentive to anyone who wants to bring a case under the Human Rights and Anti-Discrimination Bill. One of the things we did when we were talking about this bill is we thought about some examples, and we thought, well, how far could this bill actually go? And on a black letter reading of the law, we thought, well, one of the things that could happen is that if we, at the time, Julia Gillard was the Prime Minister, and if we were around the water cooler around the office and we were discussing the Prime Minister, and we may have been discussing her in less than... Not a huge fan of Julia Gillard. If the water cooler guy had come in and replaced the water, and he had been offended by us discussing the Prime Minister, he could have taken one of us to court. The IPA would have been liable for all costs. As long as he or she proved a prima facie case, it would have been up to us to prove that we're innocent. And even if we'd won that case, we would have had to pay all of our costs. It really was an extraordinary piece of legislation, an incredibly dangerous restriction on freedom of speech in Australia, and thankfully this was defeated this year. In between that period, Nicola Roxon, the Attorney General who proposed the law, resigned, and it was Mark Dreyfus who had to drop the bill eventually on the 20th of March this year. So within the space of 3 months, we went from this bill being proposed to it eventually being dropped by the government. And it's through a huge amount of work that we had done and the Australian had done and Janet had done and others at the Australian and a number of other groups had come together and really changed public opinion on this issue. And it's because of public opinion that this bill was eventually dropped. It's worth noting, however, that Dreyfus remains committed to this bill, even though he's been forced to drop it because public opinion turned against him. The second issue that I wanted to talk about was media regulation, and this is something that's been bubbling along for a number of years now, since the Finkelstein inquiry came down last year. There was a Senate inquiry into this, and this was all really over in a matter of a number of weeks. But it really was, at the time, we identified this as being an incredibly dangerous restriction on freedom of speech as well, and it was incredible that we'd had two quite severe restrictions on this freedom within the space of a few months. What was proposed by then Communications Minister Senator Stephen Conroy was a public interest media advocate. And this public interest media advocate would have been a government appointed body set up to determine whether or not newspapers and other news media organisations were engaging in conduct that was fair, that their articles were fair and accurate, and whether or not they were upholding community standards. What community standards are anyone's guess. This would have meant the removal of exemptions under the Privacy Act, unless they signed up, unless news media organisations signed up to what would have been a news media council type organisation, a press council like organisation. But not just any press council organisation, a press council approved by the government appointed public interest media advocate. At the time we called this appropriately a de facto press licensing regime, and it would have taken us back hundreds of years. Again, this was defeated by public opinion, but I say defeated by public opinion because the MPs haven't changed their mind about this. Senator Christine Milne came out and said that this could have passed if it wasn't for public opinion turning against this, as well as it had turned against the Human Rights and Anti-Discrimination Bill. What a shame. And this has all happened. This has all happened within the space of a few months. But really, this is a debate that's been happening over the last 12 years. So now I want to talk about what the opportunities are. Where do we go from here? What are the things that can be done by the incoming coalition government to change the debate? And there are two very key, very practical things that I think Tony Abbott can do. The first one is to abolish the Australian Human Rights Commission. The Australian Human Rights Commission uses $30 million every year of our money to fight not for human rights, but to undermine them. It's extraordinary. It's extraordinary that we pay commissioners on around $180,000 a year. I lie, it's $270,000 a year to work against things like freedom of association, freedom of religion, freedom of belief, freedom of conscience, and freedom of speech. They don't stand up for human rights. They're not a human rights commission. At best, they're an anti-discrimination commission, and they must be abolished. At the very least, if we can't abolish them and they must exist, then we have to reform them substantially. The way that I've proposed that we could have a human rights commission that could remain in place is to reform them such that we have freedom commissioners. We don't just have anti-discrimination commissioners, we have freedom commissioners as well. At the moment we have 6 commissioners: the President, the Age Discrimination Commissioner, the Race Discrimination Commissioner, the Children's Discrimination Commissioner, it goes on, a Social Justice Commissioner. It's time that we at least put in place freedom commissioners, and the freedom commissioners, we could have 5 freedom commissioners. We could have a rule of law commissioner, we could have a freedom of speech commissioner, we could have a freedom of religion commissioner, we could have a freedom of association commissioner, a property rights commissioner. I agree entirely. The second thing that the coalition can do is to, and it's great to hear that they've committed to at least reforming, and we hope they mean repealing, Section 18C of the Racial Discrimination Act. As I've said, this was the provision that Andrew Bolt was found guilty of towards the end of 2011. And this was the provision that was used as the basis for Nicola Roxon's major attack on freedom of speech through her Human Rights and Anti-Discrimination Bill last year. These are the two things that I hope that the government can do, and time will tell whether they actually do it. Certainly, I think these things, they must be, if we're serious about freedom of speech, they must be gotten rid of. We must have to get rid of the Human Rights Commission. We must abolish Section 18C. And I think we're presented with a real opportunity, and I hope that Tony Abbott and the Coalition grab that opportunity, because we've got 250 people in this room and there are thousands across the country that would love to see that happen.